As the motion be agreed to, the Honourable David Parker.
Thank you, Mr Speaker. Before talking to the reasons why the Labour Party believes this bill ought not to proceed, I want to record that the Labour Party is intending to allow one of our speaking slots to be used by Hone Harawira. I emphasise this not because we agree with Hone Harawira's views on foreshore and seabed, and we most plainly don't. We don't, and I outlined some of my criticisms of Hone Harawira's view on foreshore and seabed in the first reading of this bill, and I don't propose to restate those. But we do, though, sir, think that Hone Harawira is a Member of Parliament. He's clearly got a strong interest in this issue, and though it might be inconvenient for the Maori Party and the National Party to hear from him, we think this Parliament and this country should. Not because we agree with him, but because, apart from anything else, it absolutely emphasises the fact that this bill does not settle this vexed issue. This bill does not settle this vexed issue. Mr Speaker, I'm not going to recount the history...
Point of order.
I'm sorry to break in on my colleague, but members on this side of the House, when urged by the Speaker to give due consideration to Minister Tariana, did just that. I'd like that approach be accorded to our Speaker in return.
I will manage the situation. Yeah.
Thank you, Mr Speaker. I'm not going to recount the history of the existing Act. I do, though, agree that this Parliament should restore the right of iwi and hapu to make claims to the court to have their unextinguished customary interests, including customary marine titles, recognised. We do not resile from that position, but there are a number of reasons why this bill does not achieve its stated purpose and why it should not proceed in its form. If the Act did that and did it properly, then we wouldn't be here opposing it, but it doesn't. It doesn't. All that is needed now is simple legislation that protects in a statutory way public rights of access, and there's no disagreement on all sides of the House, Maori Party, Labour Party, National Party, others, that is now appropriate. Makes it clear in statute that customary title interests cannot be on-sold, that they are inalienable, and that doesn't seem to be an issue now, and then put all other issues back to the court. Because what we can't agree in this Parliament, to the satisfaction of the various interests that appear before the Select Committee and the very interests at large in society, what we can't resolve in a way that settles it is the threshold test. And there is considerable disagreement from different parties as to what the appropriate threshold test was. And we heard from Tariana Turia, the Honourable Tariana Turia, saying that in her own speech today, and I acknowledge that she has said that. There are differing views, and this Parliament has had 2 cracks at it, and we haven't settled it. It's time to acknowledge that this is one of those issues that Parliament shouldn't try and codify. It should be put back to the courts. We are not scared of that in the Labour Party. We are not scared of that in the Labour Party. And indeed, we tried to explore through the Select Committee process, and in my own dealings with the Attorney-General, tried to explore what legal advice the Crown has received as to the effect of the change to the threshold test. Prior to the bill being introduced and after the bill being introduced, I asked the Attorney to release the legal advice to the Labour Party that the Crown has undoubtedly received as to the change in the threshold test. He said he would consider it. It is within his discretion to release that advice, and he's quite within his rights not to release that advice. I don't say that he's not within his rights to withhold that Crown legal advice. But in the absence of us having access to that Crown legal advice, it was all the more important that the Select Committee got its own legal advice. Again, through Select Committee, the Labour Party members sought through the Select Committee to seek that advice from the government, because there's no sense paying for a second lot of legal advice if it's already around. In the end, the government, through the Attorney-General advice to officials, refused to release that legal advice. And so, at Select Committee, we said, well, we need other legal advice. We need legal advice from a legal expert so that the Select Committee can advise Parliament what is the effect of the change to the threshold test. And we were blocked by members of the Select Committee from doing that. The last Foreshore and Seabed Committee had good detailed advice from Paul McHugh, Queen's Counsel. And this Parliament benefited from transparent advice as to what is the effect of the threshold test. That is one of a number of procedural abuses that we at Select Committee suffered. Not only that, we had 500-page departmental report that came on a Friday afternoon to members of the Select Committee by email. Now, no one reads 500-page report properly on a computer. You didn't. No, you did not. You read the start of it. No, the member did not read the whole of the report. It was patently clear that neither he nor anyone else...
Sorry to interrupt the member. We just had a plea earlier from this side of the House to have a bit of decorum, because I understand the speakers aren't working very well. Now, this is a debate where there is some passion. There's no problem with interjections as long as they're rare and reasonable. But let's not have a yelling barrage. Let's... Honourable David Parker.
Mr. Speaker, it is clear that no one had the time to read that report properly. Mr. Speaker, on the Monday, the hard-written copy was circulated to members. On the Monday, most members were like me. They actually got it on the Tuesday morning of the same day in which the consideration of that 500-page report was at least in a pretend way conducted by the Select Committee. After less than 2 hours consideration of a 500-page report, the committee forced through deliberation. Mr. Speaker, that was quite improper. Indeed, I put a motion that we actually go through the report on a page-by-page basis, which is the normal process. That motion was blocked by government members and supported by the Maori Party. As was my motion on notice, that we get legal advice as to the effect of the change to the threshold test, as was my motion on notice that we at least provide the House with a new version of the bill that showed the changes that were being proposed by the government. But that too was blocked by the government. Why? Because in the end this is an act of politics. It's an unpopular act of politics amongst many of the National Party's supporters, and they want to ram this through Parliament as quickly as they can in the hope that it is forgotten before the election. And if anyone had a doubt of that, one would only have to reflect on the fact that they're doing this in the shadow of the earthquake, where they have been asking the opposition to put aside politics in the wider interest of a settled nation. And what's the rush? What's the first thing they do after the earthquake, after we resume for the earthquake? This foreshore and seabed. Mr. Speaker, one of the other problems with this is that this bill allows agreements between Maori and ministers. Now, the attorney has said that it will change that, and that it will require some form of supervision by Parliament. But I suggest to the House that that is a poor substitute, because what we're dealing with here is the proper and fulsome, but no more than fulsome, recognition of Maori customary interests. And the idea that Parliament will do that as assiduously, having regard to all of the different private and public interests that are at large, is, in my opinion, wrong. It is much better if that is done through the courts, who are the normal people to whom you go to protect your property rights, and who will see the proper recognition of rights, but also guard against the proper erosion of other people's rights by inappropriate recognition of rights that don't exist. So the original legislation was flawed, and that whilst it was possible to take a claim for what's now been called a customary title, what was then called a territorial customary right, it was possible to take that to the court. It wasn't possible for the court to give a remedy, and you were reliant on the grace and favour of a future government to get a remedy, and that was wrong, and the Labour Party has conceded that that is wrong, and that's why we've said that the existing bill needs to be changed. But this substitute is wrong too. This substitute goes the other way and says that there can be agreements which are tantamount, in my view, to treaty-type agreements, when what is at large here is recognition of an existing property right that ought to be properly and fully recognised, but no more than fully recognised. There's some other in the bill, sir. The bill effectively undermines, and we heard from iwi as well as from non-iwi to this effect, or not iwi, but we heard from Maori submitters as well as non-Maori, that the effect of this bill is to undermine the full and final nature of the settlements in respect of commercial aquaculture. Under that settlement, Maori rightly receive 20% of marine areas allocated for aquaculture, and they've got the right to apply for more additional space over and above the 20%. No problem with that. That was the original settlement. And that settled the underlying injustice that was the cause of the Ngāti Apa dispute in the first place. But what this bill is actually goes further and allows holders of customary rights to use their right of veto to, in addition to those two rights that I've talked about, to actually effectively get rights of veto which give them an improved negotiating position to get even more than is their entitlement under the commercial aquaculture settlement. There are other problems. We had severe criticisms of the bill that we are setting up an alternative planning regime. The Law Society, the Planning Law Association both notice that we are requiring regional councils to give effect to these plans. Mr. Speaker, there are a lot of other problems with this bill. It will not settle it. We called at first reading for a deal to be done by the Maori Party accepting this was in full and final settlement. They haven't, and we oppose the bill.